our newest, most excited member of the court here. So,
well, I'm excited about this. This is my first time actually arguing in front of this court. So, may it please the court, counsel. Your Honors, Spencer Cordell on behalf of AA Surety, and it's actually First Premier Surety was is my client who is the surety at the trial court level. Happy St. Patrick's Day to everyone as well. Your Honor, what we have is a situation where
just for a little clarification, your A&A surety or whatever is the bail bondsman in this case?
Right? First Premier is the bail bondsman.
Okay.
We have it listed as AA Surety, First Premier. AA Surety was the insurer for First Premier, who was the bail bondsman.
And then where does Lexington fit into this? I thought Lexington. I thought Lexington was the actual.
They may be the actual surety. Were they the insurance company?
Yeah.
They are the insurance company. I apologize.
Okay. All right.
Yeah. I guess it's First Premier doing business as First Premier.
Right.
They had First Premier had bonded out 2 individuals in Collier County. They fled. First Premier tracked them to New York and attempted to apprehend them, but ran into problems, were ultimately unable to apprehend them. The fugitives then apparently traveled to California. Law enforcement tracked them there. They were unable to apprehend them in time, and then they further escaped, probably leaving the country is the general belief on that.
Well, let me ask you something, Mr.
Sure.
Corda. Perhaps this will hit to the heart of the
Okay.
matter. I know the position that you're taking. This was basically an evidentiary hearing before the trial court below.
Yes.
The trial court below made when I say specific findings, when I say specific in terms of the credibility, he basically made a determination. I find this person credible. I don't find this person credible. Based on that, came to a conclusion. So my question to you, as we sit here on the appellate court, as you know, we cannot make any type of credibility type of calls. So you're taking a position in your brief that somehow the court erred in accepting this person's testimony over another. Help me out. Why?
All right. Right to the heart of it, and I don't believe that he made very specific fact findings as to credibility. He didn't say, I believe one over the other in his fact findings, and he basically made an oral pronouncement with all of his fact findings that were attached to the record and referred to in the order. He didn't say, I believe this person, I don't believe this person. Basically, he said he considered all of it and then applied the facts of those rulings. Frankly, I would have liked it if he had been clearer in his fact findings, because he actually says some things that are very good for us. He says, and it was 403 of the record, he said there may have been some errors in attempting to, when the bondsman was attempting to get a copy of the warrant, there may have been some errors. Basically, he hedged his findings, not that the clerk met their duty or fully complied, but he basically found that he thinks the case law contemplates more interference. He actually referred to it as active interference, and that was on page 402 of the record. He said that the clerk did not actively interfere, and he thinks that the clerk and the agents working for the clerk did not intentionally interfere with the surety's ability to go collect those people. Let
me ask this question.
Sure.
Assume that the trial judge credited Ms. Sims' testimony that she told Ms. Santos that you can buy a copy of the warrant. Is there a set of circumstances, assuming that's the fact, where your client wins?
There is, because I don't think my client, the clerk, or that the bail bondsman should have to buy a copy of the warrant when the clerk has a statutory duty to provide a copy of it. I don't think that there should be that extra hoop for the clerk or for the bail bondsman to jump through when time is of the essence for them to go get somebody.
But I mean, isn't there ultimately kind of a concept of materiality that bounds all of this? I mean, the theory's contractual. And
literally, we are talking about $1 here. If Judge Manuelish had said, I believe that she said you can go buy it here, and He didn't make that finding. He did not make that finding. In fact, during the evidentiary portions of this hearing ended up being stretched over a year. We had to do it in several segments. In the first segment, the clerk didn't even argue that they had told my client about these kiosks where you could get a copy or anything like that. They said the policy was to give a copy of it. And then they came back and brought Ms. Sims in, and she testified, oh no, we would have sent them to the kiosk. Judge Manuelich did not make a specific finding, as I wish he had. And he wasn't very specific. He didn't say, I believe Ms. Sims on this, I don't believe. We had two witnesses testify, Ms. Santos and Ms. Wallace, both testified that they never got that information. He did not clearly distinguish that. I wish he had, and perhaps that would be beneficial.
This is that, the time is ticking pretty quickly when you're in a piece of trying to make statutory remission. And if you're having a problem with the clerk, why couldn't you just file a motion in front of the trial court and get a quick hearing on this and get it straightened away if the dollar to pay for this or not being able to get it? I mean, a mandamus, I got a statute says I'm entitled to this, give this to me now because I've got my 60 days running.
Right. And potentially they could have, and Ms. Santos, the bondsman, is not an attorney. She doesn't know about those procedures. That's why the statute gives a clear duty to the clerk to provide that copy.
This really isn't a 903 subsection 28 remission action. I mean, you don't qualify for statutory remission. You really haven't alleged anything that is a right to remission. You're really suing the clerk for breach of this multi-party contract, aren't you?
That really is the nature of this action, and the court has put a finger on that, and that's been a recognized action for several years now, and I've cited all those cases in our brief.
But it's odd because this is just a motion filed in the criminal proceeding. It hasn't been actually filed as
right, and I think I cited it in the brief. There's a specific case that says that this is the appropriate forum to deal with bond issues. Since there's already a case open, that has been the recognized.
Do you do it by filing a motion for remission, or do you do it by filing something that would be in the nature of a breach of contract action?
That's never been done. I'm operating under it's not statutory. It really is a judicially created exception to this rule, and it's an important one. That's really why I wanted oral argument today, is to say why important it is, because if the state, be it the clerk,
Well, why is it so important? I mean, you've got, I'm assuming, I've seen them before, that you've got a contract that basically says you own this man's body, and that as long as you've got the bail situation, that you can drive to New York, put him in the trunk of your car, and bring him right back here, with or without a warrant, and you don't need to be a law enforcement officer. You just need a trunk of a car to bring this man back to Florida, don't you?
No, that's not enough, because New York has, and I don't know what New York's law's on, but they told my client they needed that warrant before she could even go up there to try to arrest somebody.
Well, she doesn't need to arrest him, except in maybe in a civil sense. If she wants a law enforcement officer to do the work for her, she needs to have an arrest warrant, and that's probably why we have this in the statute. But from the good old Wild West days of the common law, a bail bondsman's been able to just go out there and latch on, because I mean, you're in a forfeiture situation here, but even before he failed to appear, if the bail bondsman feels insecure, the bail bondsman can go.
Right, they can go
yank this guy off the street and bring him in and say, I want to put him back in jail.
And that happens sometimes. It's important because when somebody does flee, we all want, it's in everyone's interest to catch that fugitive, except the fugitive, obviously, and bring them back and have them be accountable, have them brought to justice on that. And the bondsman is the first line of defense for going out and getting that person. And if there is interference from the state, be it from the clerk, where it often comes up is somebody leaves the jurisdiction, they leave the state of Florida, and Florida says, I don't want to extradite them for another state. Or they self-deport and leave the country and say, we don't want, they're gone, fine. The bail bondsman says, we're willing to pay the cost to have them extradited and transported back here. And the state says, nah, we don't want to go get them. And I think that really ought to be their prerogative, but if they don't want to go get them and the bondsman's willing to pay whatever fees are there, the bondsman shouldn't be on the hook for that bonds money.
Those cases all involve people who are already in the custody of some law enforcement agency, right? As compared to being on the street someplace.
the Continental Surety case was one where they actually were able to direct authorities in Jamaica to arrest somebody. And that was found to be substantial efforts on the part of the bondsman, and that's kind of my secondary theory on it. Your Honor, in this case, we didn't get to that level. The clerk, or the bondsman, Ms. Santos, was not able to direct New York to arrest that person because she didn't have a copy of the warrant to give them. They told her, and she testified, they needed that copy of the warrant. She had their location, but before they could go do it, she needed that copy. And that's where she went to the clerk and tried to get it, and that's the interference.
And if I may, Mr. Clerk, that goes back to, I guess, my initial question about, there was a finding, the court, I thought, did a tremendous job orally explaining, here's what I've seen, this is what so-and-so testified, and actually use the jury instruction as to the believability and credibility of witnesses. And in a nutshell, as I review the transcript, the court came to the conclusion that unfortunately your client should have gone further. He basically accepted the clerk's testimony, rejected your client's testimony, accepted by the saying that yes, there was a kiosk there, and unfortunately your client did not go one step. And if she was thwarted, or if they were thwarted, they should have gone up through the channel. This is the finding that the court has made in terms of the witnesses that were presented. So how do we, again, we sit here to make a determination as to, aren't we bound to follow the judge's, factual determination on this?
If he had made specific factual, and I might invite this panel to send it back and see what specific factual determinations.
And you don't believe because the way he did it, he basically orally said all of that, incorporated that.
He did say that although Ms. Santos encountered some difficulties, but the clerk's witnesses all say that they would have directed anyone in this position to the kiosk. I mean, that seems to me that he's crediting what the clerk said and finding that Ms. Santos was directed to the kiosk. Why isn't that enough to dispose of it?
He's conceding that there was difficulties. Later on, he says that there may have been confusion. He at no point does he say, I don't believe Ms. Santos or Ms. Wallace or Attorney Jerry Berry, who saw them at the jail, also there trying to get a copy of the warrant. He did not specifically discredit any of the witnesses. I think, and if you look specifically at what his findings, he literally went through all of the testimony and laid it all out, but at no point does he say, I don't find this credible. And when he finally applied the law to his findings, he says there was an active interference. I don't find that the clerk intentionally failed to do these things. And I think reading between the lines that they did have some failures, it just wasn't intentional. They weren't, and I'm not saying that they were intentionally trying to keep Ms. Santos from getting to these people. I don't think that was in their interest. I don't think they realized what they were doing, but I think it's important that there does not need to be active interference on that. When they have a statutory duty to do something, their end of the three-party contract is that they have a duty to give that warrant. Their intent doesn't matter. If they want to do it or if they're actively doing it, if it fails to get to the bondsman timely, they're in breach. And the case I wanted to point to most specifically on that was the Singh v. Brock case. And in that case, Brock argued that the bail bondsman was in breach, and they shouldn't, basically made it a strict liability situation that they were not entitled to remission because they were in breach. Well, if the bail bondsman is in breach, then, if the clerk is in breach, it ought to be strict liability for them as well.
Factually, there's a couple of things that I'm not sure I got the timeline on correct.
Okay.
So, when your clients are down talking to the clerk trying to get the warrant, at that point in time, do they know this fellow's in New York?
I believe so, yes.
And
I believe the timing on that.
Do we know what the window of time was when this person apparently left New York and went to California or parts unknown?
It was within a few weeks. We don't know specific. I want to say it was October that they located him in New York, and early November that there was information that they were in California. So it was a fairly short window of time that they were in New York. And there were 2 attempts.
And apparently your theory is that there was enough information for law enforcement in New York to pick him up, whereas apparently that was never quite the case in California.
Actually, there might have been substantial information, and Ms. Santos, the bail bondsman, was not involved in the California operation. I think there was a delay there in informing California authorities that, yes, Collier County was willing to extradite, and probably due to that delay, they were able to flee the country and flee California. We don't benefit from that because that was not Ms. Santos's efforts. But basically, they went to New York for a few weeks, California for maybe a few weeks, and then they were pretty quickly gone after that. The timeliness is of the essence of this, and so any delay, and the testimony was that Ms. Wallace and Ms. Santos first called down to the clerk's office, weren't able to get a copy, then went in person and were not able to get a copy. They also tried the sheriff's office, which is, the sheriff doesn't have the statutory duty, it's the clerk that has the statutory duty.
And I guess, you know, the trial judge also seemed to me to conclude that your client's efforts to secure the return of the defendants did not reach the level of substantiality that 90328 requires. How do we get past that?
Because in this circumstance, they were limited on how far they were able to go because of the failure of the clerk to provide a copy of the warrant. Unlike the Surety Continental case where they actually directed somebody to get picked up and the state refused to extradite, they weren't able to get to that step because New York needed a copy of the warrant and Ms. Santos wasn't able to get it to provide to New York. So basically, the failure of the clerk's breach in not providing that copy of the warrant cut it off at that point. Again, intent doesn't matter. The fact that they weren't actively trying to keep her from doing it, they didn't meet their duty on that.
If I may, Mr. Cruz, I'm going back to the record, and here's what the court said, and I quote, "I don't think that the clerk's witnesses were lying as to their desire not to cooperate. Frankly, I have had nothing in the evidence that would indicate any motive or reason that they would have wanted to be difficult with Ms. Santos." And here's the next one. So I'm not saying that Ms. Santos didn't encounter some confusion, and here's the quote, "but I don't think it was to a level of interference by the clerk's office." So he made a determination that he does not, again, it's a credibility call based on the testimony that he did not believe that the clerk interfered. And I guess my question is, I think you're putting too much emphasis on maybe one word where he says active interference versus any, basically you're saying that did the clerk's office put up obstacles that would hinder your client from going forward? The court came to the conclusion that no, that was not the case.
I think that word active is important because he's not making a specific finding that he doesn't believe my client and her efforts and that she wasn't initially able to obtain it. He's talking, and he said also in there, about the intent. He says, I don't think that they wanted to do this. I don't think that they're actively doing it. By couching that, it suggests that there was a problem. He said there may have been, the court found that there may have been difficulties. He found that there may have been errors. Those were also in fine. So he didn't, I wish he had said, I believe them, I don't believe them, and this is why I'm ruling that way. He summarized everything and says, I don't think they intentionally did it. I don't think they were actively interfering, and then he applied the law based on this belief of active interference. And I don't think the statutes require active interference. I think they have an affirmative duty on the clerk to provide that copy. And so their active interference is irrelevant. Their intent to do that is irrelevant. And I think he kept talking about active interference and whether or not they wanted to do it, and I think he was caught up on whether or not the clerk was trying to keep the bail bondsman from getting that. I'm not saying they were, but it's irrelevant. And I wish he had been clearer on that because there's obviously ambiguity in the way that he worded that and made his findings, because at no point does he say, I find Ms. Santos's testimony uncredible.
Mr. Cordial, as often happens to me, got so interested in your argument that I didn't watch the clock. So we're well beyond your 15 minutes, but I'll save you 3 minutes for rebuttal.
Thank you. I appreciate that.
All right.
Hi, Mike.
Mr. Pierce.
Thank you very much, Your Honor. Anthony Pierce on behalf of the Clerk of Courts. I think it's an important part that the court has already focused on is the trial court was sitting as a trier of fact. It wasn't just a motion to dismiss type of situation where it's mixed questions of law and fact. And as you know, the court has indicated, Judge Kuzum has indicated, that the trial court made very detailed and specific findings of fact and made determinations of the credibility of the witnesses, and the court had the witnesses there before them. And part of the issue with
regard... It troubles me, though, that if you really accept the theory that, yeah, sure, all that your employees told this person to go to the kiosk, it was a pretty simple thing to go to the kiosk, and they didn't, and, you know, there was a lot of money on the line, and it seems rather incredible to me that the employees actually would have said go to the kiosk and they didn't do that, and that Jerry Berry didn't hear him say that.
Jerry Berry was not at the clerk's office. Jerry Berry was at the sheriff's department, and the testimony of Jerry Berry, and Jerry Berry didn't even acknowledge that he knew Mrs. Santos. He did not know the name. I believe the record was there was a lady who had a commotion and an issue at the sheriff's department, and that was it. And he wasn't at the clerk's office. And I think it's important that Jenna Smith's testimony was very clear. She had one call on this. She told the caller how to obtain the documents, told the caller you can make the request in writing, which the rules of judicial administration require, that the request for court records be in writing. So that's another important aspect that can't be overlooked. The clerk is bound by those rules. The trial court made a determination, I find it page 401, it said, I think the easiest aspect of this would be to first look at the interference aspect. In other words, the trial court made the determination, evaluated the testimony, and made the determination of the credibility of the witnesses. And as the court has pointed out at page 403 of the record, so I don't think it was to a level of interference by the clerk's office. And again, at page 404, so all things considered, it wasn't a perfect scenario, but I don't think, given the emphasis on whether there's interference, which I'm not finding it.
What kind of theory do you think this interference is? I mean, you've argued in your brief, and I think with some accuracy, that this really isn't a claim for remission. Remission's a statutory creature, and that you have to have found the body before you get remission. They didn't do that.
Yeah, I agree. It may not be the appropriate vehicle. One other aspect that's interesting is...
So what is it then? I mean, is this is it a breach of contract? Is it a tort?
It's not a breach of contract. And once again, I think the bail bondsman, I can't get into their head at the time, thought that that was the only available remedy that was available.
If you find that the clerk's office interfered in a fashion by not giving a warrant, let's change the facts, and it's an intentional situation, and it's actually the cause of why they couldn't arrest this fellow in New York. It's not so much that you get your money back. This is where does the money come from?
Well, I think
at that point in time?
I think it's also important to know that they substantially attempted to procure the presence of the individual, and I don't believe there's any evidence to that. I think the court even indicated that there wasn't any evidence of substantial efforts to procure the appearance. It said they had leads in New York, and they were on the verge.
Let me go back to my question. When bond money is paid in this fashion, and the person never shows up, where does that money go?
The money goes, when it's forfeited, the money goes into the fine and forfeiture fund, which then is allocated by the Clerk of Courts Corporation, goes to the Clerk of Courts Corporation, allocated by the legislature. The clerk has no control as to what happens after that. So it's not a windfall.
If this clerk has either breached a contract or committed a tort or violated a statute, and they're out $160,000 or whatever the number is, that's not the money that's used to pay that claim, is it?
I'm not sure I understand the question, Your Honor.
Well, the money is not subject to remission by statute. That money is supposed to go to the funds that the legislature says it goes to.
Correct.
So it seems to me that if the bail bonds people have been damaged in this case, that the money ought to come from some other source that's the clerk's money, I would think, because that's where the breach took place.
Well, allegedly. And again,
right.
we disagreed.
I'm on a hypothetical basis. I'm just trying to understand what our theory is that this case law is creating.
I think the theory is that they were entitled to remission under the statute, but our argument is they're not entitled to remission under the statute.
So all those cases are wrong?
Well, the case is dealing with regards to the interference aspect.
Right.
They've created a new aspect, I think carved out a very narrow exception to the situations where the individual bail bondsman or surety is not able to...
It's like a due process violation of sorts.
I'm not exactly sure. Unfortunately, the case laws don't elaborate as to the reason. They just make the statement.
That's why I'm asking.
No, and I have thought about that myself.
I don't quite understand this theory, and
where did this come from, Judge?
It's like a civil rights theory we ought to have a jury trial on rather than a hearing on remission is why I'm trying to...
I was thinking the same thing. Maybe the courts thought they were doing equity. I don't know. But again, there's no elaboration in those appellate opinions as to the basis.
Could they have moved to set aside the forfeiture? Would that have been an available procedural vehicle for this?
They would have had the time, they would have had to do that, but once again, they had to make, the key issue is making the payment also.
Right,
If you don't hit,
the 60-day window is very important.
that's very narrow.
Right.
And one other aspect too, as far as the conflict.
And actually, typically, and this is, I think, where the confusion comes in, this is all ingested in the criminal court system because it happens in the criminal court setting, and usually it's the criminal administrative judge who handles all of that. So you have attorneys that are perhaps more for criminal, that do criminal law, now injecting, this is actually a civil type of matter. And we've seen, I mean, on the trial court, it used to be a motion to vacate, the bond, motion to street the bond, motion for whatever. So it's been, like Judge Alterman and Judge Solero said, it's all over the place. And I think that adds to the confusion. I think the body of law, they try to say, well, okay, what has been done? So that the analysis is still done by the trial judges, but it's utter confusion out there.
Well, it's interesting, and also from an aside, the initial action is a criminal action, but then it's styled at times as a criminal action, then it comes up here and it's a civil action.
This is really a civil action between the bail bonds people and the clerk.
It does make life interesting, and from a procedural perspective.
Neither the state nor the defendant, who is long gone, has any stake in this.
That's correct. They usually stay away. Well, and one issue again with regards to the conflict, interestingly enough, in his closing argument, the appellant's counsel, Mr. Cordell, acknowledged that. He said it, page 700 of the record. Mr. Cordell, Your Honor, what we have here is there ultimately is a conflict in the evidence here, and I believe the court is going to have to make a determination as to which evidence is reliable. And the court did that. The court made the determination that there was no interference, that the records were readily available, that the clerk's office did make them available at the kiosk, a publicly accessible clerk's kiosk existed. And Jenna Sims testified that she told the caller that's how you can get the record. There were no substantial attempts by the surety or bail bond company to return the defendants. We have, again, this nebulous concept about there's someplace in New York City, no exact address, and the NCIC, FCIC information that was in the record that was provided does not reflect any entries that law enforcement was provided, any information that they were in New York City. The only entries are in reference to California. And to the question that Judge Altenburn was asking, according to the record, page 306, warrant management, and it talks about that on October 18th, 2012, Accurate shows an address in California. And they emailed asking if they can check on extradition. An email was sent to the state attorney's office on October 18th. And October 19th in the record is the email response by Assistant State Attorney Scuderi. That's a Friday, saying we will extradite. And the information is entered on a Monday, October 22nd. And that's California. So again, I think the court listened to all the testimony where there was the uncertainty on the part of Ms. Santos and Ms. Wallace as to various events, who they told and what they told.
Was there direct evidence or merely hearsay evidence that the person to be apprehended was in New York?
According to my recollection of the record is that Ms. Santos had developed some information from a confidential source that the person was in New York. And there was objections to further inquiries. Mr. Cordell made objection to the clerk inquiring as to what was the nature of that confidential source. What was the actual information? So it was a very, very small piece of it, Your Honor. So that, and once again, I think it's merely a lead, as the trial court indicated. It was a lead. Unlike the other cases like, county bonding agency where there was presumed to be no prejudice because the prosecution wasn't thwarted or delayed. In Continental Surety, that was a much different case. It was referenced that the Jamaican authorities had sent a letter saying, hey, we'll arrest this guy. Do you want him? And they said, no, we're not going to extradite. But in this case, I think the clerk followed the procedures, advised the individual of how to get the records, followed the Supreme Court's rules with regards to redacting the necessary information, confidential information from the record, and is required, I cited all those cases where the clerk is mandated to charge the requisite fee. Charging a fee is not interference. It's mandated by the statutes and by all the case law. And it's interesting too, in WTF versus Wilkin it cites to a case that says requiring payment for records is not of an inmate. Requiring him to pay for records, which is a constitutional right to obtain those records, is not interference with his ability. And so I guess based upon all the evidence before the trial court, that multiple points that were not met. As the court, I won't go over it again, the trial court was sitting as a trier of fact. After forfeiture, and after the appellants have the burden to show substantial procurement or attempt to surrender, the trial court found that did not exist. And the absence of prejudice to the proper prosecution of the case. There was no testimony on that. So there's no testimony that prosecution wasn't thwarted or delayed. And as we've discussed earlier, there's no other basis for remission other than outlined in the statute. They've not met their burden with regards to showing that they have substantially attempted to procure, and there was no interference by the state. In fact, the state actively tried to find these individuals. Mike Hedberg testified about that, the communications back and forth with the state attorney's office about extradition, and the state has not refused to cooperate. And we would submit that in this case that the trial court be upheld, the ruling was correct, and no error has been shown.
Okay, thank you.
Thank you.
Mr. Cordell?
Briefly, Your Honor. Thank you. I want to briefly revisit the issue on how clear the court's fact finding was as to the dispute in the evidence. Judge Manleysh did find the evidence shows there was some difficulty that Ms. Santos encountered with the procedure. He went on to say she clearly testified she was not getting the relief, and then he faulted her for not seeking a supervisor. And that's actually an error in Judge Manleysh's recollection of the testimony, because Ms. Sims testified she was a supervisor. She was in charge of all bail bonds and child support things or some additional things. She was actually not just the low-level line clerk at the clerk's office. She had a managerial role at the clerk's office. And I don't think that the clerk has a duty to give that warrant. It's not incumbent upon the bondsman to go up the chain or seek a supervisor. Ms. Santos didn't know what to do. She had spoken to the supervisor at the clerk's office. She didn't know to file a writ of mandamus. She tried the sheriff's office. Not because that was the place to get it, but because the sheriff's office in Lee County had given those warrants to her before. That wasn't the procedure in Collier County. They had recently installed those kiosks. The testimony was it had just been a few months before all of these incidents. It doesn't do any good if there are kiosks available if it's not clearly instructed to Ms. Santos that you can get it right there. And the court's finding was that she clearly was not getting relief and she encountered problems. So I think Judge Manleysh found her pretty credible in her testimony. It might be proper to ask Judge Manleysh to clarify that if the court has concerns about that, but he couched his argument. He says, I think the case law, my view of the case law is that it contemplates substantially more of interference or lack of cooperation, and then later on he talks about that active interference. So I think, and he didn't say that they weren't as forthcoming as they should have been, but I think he was couching the law that he applied, he was anticipating there needed to be something affirmative, either intentional or something more substantial. And when the statute gives the clerk an affirmative duty, it doesn't need to be intentional, it doesn't need to be active. If they fail to meet that duty, they're in breach, and Ms. Santos should be entitled to a remission.
Okay.
Thank you, Your Honors.
Well argued. Next case on the docket is Rivera versus Highwoods Properties.